I woke up that Tuesday morning to find my boat gone from my driveway, and for a solid 5 minutes, I genuinely thought I was losing my mind. My name is Ryan Daniels, and I had lived in the Sunset Ridge Estates community in Scottsdale, Arizona, for exactly 8 months. The place was beautiful, with manicured lawns, palm trees lining every street, and houses that all looked like they belonged in an architecture magazine. I had bought my 3-bedroom ranch-style home with the money I had saved from 10 years of working as a commercial electrician, and it was supposed to be my slice of the American dream. The property had a wide driveway that could easily fit 3 vehicles, and when I bought my 2019 Bayliner VR5 Bowrider last month, I figured parking it in my own driveway would be perfectly fine. I was wrong. I stood there in my bare feet and pajama pants, coffee mug in hand, staring at the empty spot where my 22-foot boat should have been. The early morning Arizona sun was already warming up the concrete, and I could hear my neighbor's sprinklers running on their automatic timer. Everything seemed normal except for the glaring absence of my $40,000 boat. My first thought was theft. My heart started hammering in my chest as I walked down the driveway, looking for any signs of a break-in or forced entry. The trailer hitch lock I had installed was gone too, which meant whoever took it knew what they were doing. I pulled my phone from my pocket and was about to dial 911 when I noticed a bright yellow piece of paper stuck to my mailbox. The paper was an official-looking notice from the Sunset Ridge Estates Homeowners Association. My hands were shaking slightly as I unfolded it, partly from adrenaline and partly from the growing sense of dread in my stomach. "Dear resident," it began in formal typeface. "Your vessel has been removed from your property due to violation of HOA Covenant Section 4.7, which strictly prohibits the parking or storage of boats, recreational vehicles, commercial vehicles, or trailers in any driveway or visible area of residential properties. Your vessel has been towed to Desert Storage Solutions, 4892 East McDowell Road, Phoenix, Arizona. You may retrieve your vessel upon payment of towing and storage fees. Failure to retrieve your vessel within 30 days will result in additional penalties." This action was approved by HOA Board President Patricia Morrison and enforced in accordance with community guidelines. I read the notice 3 times, each time feeling my blood pressure rise a little higher. They had towed my boat from my own property. Not from the street, not from a public area, but from my private driveway on land that I owned. I went back inside and immediately started Googling. I pulled up my HOA documents that I had signed when I bought the house. Documents I admittedly had only skimmed through at the time because they were nearly 100 pages long and filled with legal jargon. I spent the next 2 hours reading through every single page, and there it was, buried in Section 4.7 exactly like the notice said. No boats, RVs, or commercial vehicles visible from the street. The thing that really got me angry was that nobody had warned me. No friendly neighbor stopping by to mention the rule. No initial notice from the HOA asking me to move it. They just went straight to having it towed. I got dressed and drove straight to the address listed on the notice. Desert Storage Solutions was a dusty lot surrounded by chain-link fencing and razor wire, filled with vehicles, boats, and equipment that had been towed or stored. The office was a single-wide trailer with a window air conditioning unit that sounded like it was on its last legs. A bored-looking guy in his 20s sat behind a desk, scrolling through his phone. His name tag said Derek. "Help you?" he asked without looking up. "Yeah, you guys towed my boat last night. I need to get it back." That got his attention. He set his phone down and turned to his computer. Name, Ryan Daniels. It is a Bayliner VR5, white and blue. He typed for a moment, then nodded. Yeah, got it. Tow fee is $450. Storage is $75 per day. Wait, $75 per day? It has been here less than 24 hours, Derek shrugged. That is the rate. Plus the tow fee, you are looking at $525 to get it out today. I wanted to argue to tell him this was ridiculous, but I knew it was not his fault. He was just doing his job. I pulled out my credit card and paid the fees, wincing as the charge went through. The boat had already cost me enough, and now I was down another $500. Derek printed out a release form and handed me a set of keys. Bay 7, around the back. You got something to tow it with? Yeah, my truck is right outside. 20 minutes later, I was backing my Ford F-150 up to the trailer, hooking everything up and checking the connections. The boat looked fine, no damage that I could see, which was at least something. I signed the release paperwork and drove out of that lot feeling angrier than I had felt in years, but I could not take the boat home. That was the infuriating part. I had to find somewhere else to put it, at least temporarily. I ended up driving to my buddy Marcus's house in Temp. He had a larger property with no HOA, and he said I could park the boat in his side yard until I figured things out. Man, that is messed up, Marcus said as we pushed the boat into position. He was a big guy, former college linebacker with a shaved head and a perpetual smile that disappeared when I told him what happened. They just towed it without warning. Not a single word, I said. Just woke up and it was gone. What are you going to do? I do not know yet. But I am not just going to roll over on this. I spent that evening researching Arizona HOA laws, reading through statute after statute. What I found was interesting. Arizona law actually had pretty specific requirements about what HOAs could and could not do. They had to provide notice before taking action. They had to give homeowners an opportunity to correct violations. And they definitely could not just tow vehicles from private property without following proper procedures. The next morning, I drafted a formal letter to the HOA board. I kept it professional but firm, explaining that they had violated Arizona Revised Statutes Section 33-1803 by failing to provide advance notice, and that I expected full reimbursement for the towing and storage fees. I sent it via certified mail so I would have proof they received it. 3 days later, I got a response. It came in a thin envelope with the HOA's return address printed in the corner. Inside was a single-page letter on official letterhead. Dear Mr. Daniels, it read. The HOA board has reviewed your complaint and finds no merit to your claims. The covenant restrictions were clearly outlined in your purchase documents, and all residents are expected to be familiar with community rules. The towing action was proper and necessary. No reimbursement will be provided. Future violations will result in daily fines of $100 until compliance is achieved. Sincerely, Patricia Morrison, HOA Board President. That was it. No discussion, no acknowledgement of the procedural violations, just a flat denial and a threat of more fines. I tried calling the number listed on the letterhead. It went to a voicemail box that was full. I tried emailing the address listed on the HOA website. No response. I even tried going to the HOA management office listed in my documents, only to find it was a mail forwarding service with no actual people there. Patricia Morrison apparently had no interest in talking to me. Fine. If she wanted to play hardball, I could play hardball too. I made an appointment with a lawyer. His name was Gerald Patterson, and he specialized in HOA disputes. His office was in a professional building in downtown Scottsdale, all glass and steel and modern furniture. Gerald himself was probably in his 50s, with gray hair and the kind of calm demeanor that suggested he had seen every kind of legal drama imaginable. I sat across from him and laid out the whole story, showing him all my documents, the towing notice, the letter from Patricia, everything. He listened carefully, occasionally taking notes on a yellow legal pad. When I finished, he leaned back in his chair and nodded slowly. "You have got a good case," he said. "HOAs in Arizona have to follow specific procedures before taking enforcement action. They should have sent you a notice of violation, given you typically 10 to 30 days to correct it, and only then could they take further action. Towing your boat without that process is a clear violation of state law. So what do? We file a complaint in Superior Court. We will ask for reimbursement of your fees, damages for their violation of procedure, and an injunction preventing them from taking further action against you without proper notice. How long will that take? Court cases can take months, sometimes over a year. But in a case like this, we can request an expedited hearing. The facts are pretty straightforward. And how much is this going to cost me? Gerald gave me a sympathetic smile. I charge $250 an hour. A case like this, if it goes to trial, you are probably looking at $10,000 to $15,000 in legal fees, maybe more if they fight hard. I felt my stomach sink. I had already paid $525 to get my boat back, and now I was looking at potentially $15,000 in legal fees to fight this. It seemed insane. However, Gerald continued, if we win, we can ask the court to award attorney's fees. Arizona law allows for that in HOA disputes when the HOA acts improperly, so there is a good chance you would get all your money back. And if we lose, then you are out the legal fees. But honestly, Ryan, based on what you have shown me, I do not think we will lose. This is pretty cut and dried. I thought about it for maybe 30 seconds. The principle of the thing was eating at me. I had worked hard for everything I owned. I had saved for years to buy that house and that boat. And some power-hungry HOA president thought she could just take my property without even talking to me first. No. I was not going to let that stand. "Let us do it," I said. Gerald smiled and pulled out a retainer agreement. I signed it and wrote him a check for $5,000 as an initial retainer. My savings account was taking a serious hit, but I was committed now. Over the next 2 weeks, Gerald prepared our complaint. It was a detailed document, 23 pages long, outlining every violation the HOA had committed, citing specific Arizona statutes and requesting specific remedies. We filed it with the Maricopa County Superior Court on a Wednesday morning. The HOA had to be formally served with the complaint. A process server delivered it to Patricia Morrison at her home 3 days later. I knew this because Gerald got the signed proof of service back. Then we waited. The HOA had 20 days to respond to the complaint. During that time, I kept living my normal life, going to work, coming home, maintaining my lawn to the HOA's exacting standards. I had moved the boat to a storage facility that cost me $150 a month, which was another expense I was tracking for the lawsuit. My neighbors started treating me differently. Word had apparently gotten around that I was suing the HOA. Some people gave me encouraging nods or thumbs up when they saw me. Others avoided eye contact and hurried inside when I came out. The neighborhood gossip chain was clearly working overtime. On day 19, the HOA filed their response. Gerald called me as soon as he got it. "They are denying everything," he said. "Their response basically says they followed all proper procedures, that the covenant restrictions are valid and enforceable, and that you are a disgruntled homeowner trying to avoid following the rules everyone else follows. That is complete garbage. I know, but it is what they are claiming. The good news is their response is pretty weak. They did not provide any evidence that they sent you advance notice because they cannot. It does not exist. So what happens now? Now we go into discovery. We will send them interrogatories and document requests. They will do the same to us. We will gather all the evidence and then we will get a court date. The discovery process was tedious and invasive. The HOA's lawyer, a woman named Susan Feldman, sent over questions that asked about every aspect of my life. My income, my purchase of the boat, my knowledge of HOA rules, my communication with neighbors, everything. I spent hours with Gerald going through each question, crafting careful answers. We sent our own discovery requests to the HOA. We asked for copies of all their records related to my property, all communications between board members about me, their policies and procedures for enforcement actions, records of other towing incidents, and financial records showing where the HOA's money was going. The HOA was slow to respond. They asked for extensions multiple times. When they finally produced documents, they were heavily redacted. Financial records had entire sections blacked out. Board meeting minutes were incomplete. It was obvious they were hiding something. Gerald filed a motion to compel, asking the judge to order the HOA to produce complete documents. The hearing for that motion was set for a Thursday morning in late November. I took the day off work and met Gerald at the courthouse. It was my first time seeing Patricia Morrison in person. She was exactly what I expected. A woman probably in her late 40s with an expensive haircut, designer clothes, and an expression that suggested she smelled something unpleasant. She sat at the defendant's table with Susan Feldman, whispering back and forth while we waited for the judge. Judge Elizabeth Harper came out right at 9 in the morning. She was an older woman with sharp eyes and a no-nonsense demeanor. She had clearly reviewed the motion in advance because she got right to the point. Miss Feldman, your client has produced heavily redacted documents in response to legitimate discovery requests. What is the justification for these redactions? Susan Feldman stood up. Your Honor, the redacted information contains private details about other homeowners and sensitive financial information that is not relevant to this case. Mr. Patterson, the judge asked, looking at Gerald. Gerald stood. Your Honor, we are not asking for information about other homeowners. We are asking for the HOA's financial records as they relate to their enforcement policies and where fines and fees are going. The defendant is using privacy concerns as a shield to hide evidence of improper conduct. Judge Harper nodded slowly. I tend to agree, Miss Feldman. Your client will produce complete, unredacted financial records for the past 3 years, limited to information about enforcement actions, fines, towing fees, and board expenses. You have 10 days. Anything else? No, Your Honor, both lawyers said. Then we are adjourned. The whole hearing took maybe 15 minutes, but it felt like a victory. As we walked out of the courtroom, I saw Patricia Morrison staring at me with pure venom in her eyes. I smiled and nodded at her. She turned away sharply and stalked off down the hallway. 10 days later, the HOA produced the unredacted financial records. Gerald called me that evening, and I could hear the excitement in his voice. Ryan, you need to come to my office tomorrow. I have found something very interesting. I was there first thing in the morning. Gerald had the financial records spread across his conference table, with certain sections highlighted in yellow. Look at this, he said, pointing to a series of entries. Over the past 2 years, the HOA has had 47 vehicles towed, Boats, RVs, commercial trucks, everything. Each time they used the same towing company, Desert Storage Solutions. Yeah, that is where they took my boat. Right, now look at the payments. The HOA receives a fee for each vehicle towed, 20% of the total towing and storage charges. I stared at the numbers. Wait, what? They are getting paid. Exactly. It is a kickback arrangement. The towing company pays the HOA a percentage of what they charge the homeowners. Over the past 2 years, the HOA has received over $60,000 in these payments. Is that legal? Gerald shook his head slowly. It is legally questionable at best and outright fraudulent at worst. HOAs are supposed to operate for the benefit of homeowners, not to generate profit through enforcement actions. This looks like a scheme to generate revenue. Where is the money going? That is the other interesting part. He flipped to another section of highlighted documents. Look at these expense reports. Patricia Morrison has been charging thousands of dollars to the HOA for things like meals, travel, conferences, and consulting fees. In the past year alone, she has charged over $35,000 in expenses. For what? What does an HOA president even need to travel for? Exactly. This smells like embezzlement. She is using the kickback money to fund personal expenses and passing them off as HOA business. I felt a mix of emotions, anger at the corruption, but also satisfaction that we had found it. What do we do with this information? We amend our complaint to include fraud and breach of fiduciary duty claims. And honestly, Ryan, this might be criminal. I think we need to report this to the Arizona Attorney General's office. Will that help our case? It will not hurt it. And more importantly, it is the right thing to do. If Patricia Morrison is stealing from homeowners, she needs to face consequences. We spent the next week preparing an amended complaint and a detailed report for the Attorney General. The amended complaint was even longer than the original, laying out the kickback scheme, the questionable expenses, and arguing that the entire towing action was motivated by profit rather than legitimate rule enforcement. We filed the amended complaint in December. The local news got wind of it somehow, probably from court filings being public record. A reporter from the Arizona Republic called me asking for an interview. I ran it by Gerald first. It is up to you, he said. It could help put public pressure on the HOA. But it might also make things more contentious. They towed my boat and tried to extort me. I do not care about contentious anymore. I did the interview. The reporter, a young guy named Kevin Chen, was thorough and professional. He asked about the boat, the towing, the discovery of the financial scheme, all of it. He also reached out to Patricia Morrison for comment. According to Kevin, she declined to be interviewed, but her lawyer sent a statement saying all allegations were false and defamatory. The article ran on the front page of the local section 2 days later. Scottsdale HOA accused of kickback scheme in towing dispute. It laid out the whole story, included comments from me, and from HOA legal experts who said the arrangement described in the lawsuit raised serious red flags. The response was immediate. My phone started ringing with calls from other Sunset Ridge homeowners who had similar experiences. A guy named Tom had his RV towed the previous summer. A woman named Jennifer had her work van towed even though she had applied for an exception. They all paid the fees, felt like they had no choice, and never knew about the kickback arrangement. Gerald suggested we might be able to bring this as a class action, representing all the homeowners who had been affected. But that would complicate things and take longer, so we decided to stick with my individual case and let others file their own lawsuits if they wanted to. The Attorney General's office was slower to respond. I did not expect anything quick from a government agency, but after the news article ran, they sent a letter acknowledging receipt of our complaint and saying they were opening an investigation. Meanwhile, our trial date was set for late February. That gave us about 2 months to prepare. Gerald subpoenaed records from Desert Storage Solutions, interviewed witnesses, and prepared his examination questions. I had to sit for a deposition, where Susan Feldman asked me hostile questions for 4 hours straight. Gerald prepped me well, though, and I kept my cool, answering everything honestly and not taking the bait when she tried to make me angry. Patricia Morrison's deposition was scheduled for mid-January. Gerald said I could attend if I wanted to, though I would have to sit quietly in the room. I took another day off work to be there. Patricia showed up in a black pantsuit with Susan Feldman at her side. She looked nervous, which was satisfying to see. The deposition was held in a conference room at Susan's law office. A court reporter sat in the corner, typing everything on her little machine. Gerald started with basic questions. Her role with the HOA, how long she had been president, what her responsibilities were. Patricia answered in clipped, careful sentences, clearly coached by her lawyer. Then Gerald moved to the towing policy. When did the board decide to start enforcing the covenant restriction on boats and RVs? He asked. We have always enforced it, Patricia said. But according to the records we received, there were very few towing incidents before 2 years ago. Then they increased dramatically. Why is that? Patricia shifted in her seat. We decided to take a more active approach to enforcement. The neighborhood was starting to look cluttered. And when you decided to take this more active approach, did you solicit bids from multiple towing companies? I do not recall. You do not recall. You are the president of the board. Surely you remember whether the board got competitive bids for a major contract. We used the company that was most convenient, Desert Storage Solutions. Yes. And did you know that Desert Storage Solutions agreed to pay the HOA 20% of all fees collected? Patricia's eyes flicked to Susan, who put a hand on her arm. Do not answer that, Susan said. That calls for legal conclusions about the nature of the arrangement. Gerald smiled slightly. I will rephrase. Were you aware that money was being paid from Desert Storage Solutions to the HOA's bank account? Another pause. I was aware that we had a processing fee arrangement, yes, a processing fee. Can you explain what the HOA was processing that justified receiving 20% of all towing fees? We were processing the violations, sending notices, coordinating with the towing company. Miss Morrison, in Mr. Daniels' case, did you send him any notice before having his boat towed? The covenant restrictions are notice enough. That was not my question. Did you personally, or did anyone on the board, send Mr. Daniels a specific notice about his boat before calling the towing company? Silence. Patricia looked at Susan again. Susan nodded slightly. No, Patricia finally said. So you did not process anything in his case, correct? You just saw the boat, called the towing company, and collected your 20% when he paid to get it back. That is a mischaracterization, Susan interjected. We are not going to sit here and let you badger the witness. I am asking straightforward questions about her actions, Gerald said calmly. Miss Morrison, let me ask you about these expense reports. He slid a stack of papers across the table. These show you charged the HOA for a trip to Hawaii last March. What was the business purpose of that trip? Patricia picked up the papers and flipped through them. There was an HOA conference in Honolulu. I attended sessions on community management and board governance. Do you have any documentation from this conference? Agendas, materials, certificates of attendance? I might have them somewhere. Please produce them within the next 7 days. Now, these dinner charges, 5 separate occasions where you charged meals totaling over $3,000. Who attended these dinners? Other board members and community stakeholders. Can you provide names? I would have to check my records. Please do so. Miss Morrison, have you ever used HOA funds for personal expenses? Absolutely not. Are you certain about that? Yes. Even though these records show charges at department stores, spas, and hair salons, all coded as business expenses, Patricia's face was getting red. Those were legitimate expenses related to my duties as board president. I need to maintain a professional appearance. Your position as board president is voluntary and unpaid, correct? Correct. So why should homeowners be paying for your hair appointments and spa visits? I think we are done here, Susan said, standing up. My client has answered your questions. This is clearly becoming harassment. We have been going for 90 minutes, Gerald said. I have a right to complete my examination. Then stick to relevant questions. They went back and forth for a few more minutes, but the deposition continued. Gerald asked about other towing incidents, about board meetings, about how decisions were made. Patricia's answers became shorter and more defensive. By the time we finished 3 hours later, it was clear she was rattled. As we left the building, Gerald was smiling. That went very well, he said. She contradicted herself multiple times, admitted there was no advance notice, and her explanations for the expenses are obviously fabricated. You think we will win? I think we have a very strong case, but you never know what a judge will do. We need to keep preparing like we might lose and need to make every argument count. The next few weeks were a blur of preparation. Gerald drafted motions, prepared exhibits, and worked with an expert witness, a guy who specialized in HOA management and could testify about proper procedures. I gathered every document I had related to the boat purchase, the towing, the expenses I had incurred, everything. The trial was set for February 23rd. As the date approached, I found it hard to focus on anything else. My work was suffering because I kept thinking about the case. My sleep was terrible. I was anxious and angry and determined all at once. The weekend before trial, Marcus invited me over for a barbecue to try to get my mind off things. We sat in his backyard, drinking beer and watching the sun set over the mountains. "How are you holding up?" he asked. "I am okay, just ready for this to be over. You are doing the right thing, you know, standing up to them. I hope the judge sees it that way. Even if this costs you money, even if it is a pain in the ass, you are making them think twice before they do this to someone else. That matters." I appreciated Marcus trying to make me feel better, but the truth was I needed to win this. Not just for the principal, but because I could not afford to lose 15 grand in legal fees on top of everything else. Monday morning arrived cold and clear. February in Arizona can be surprisingly chilly in the mornings, and I wore a suit Gerald had helped me pick out. Navy blue, conservative, the kind of thing that said responsible homeowner rather than troublemaker. The courthouse was busy with various cases being heard. We checked in and waited in the hallway outside our assigned courtroom. Patricia Morrison arrived with Susan Feldman, and we ignored each other. Also present was a representative from Desert Storage Solutions, a nervous-looking man in his 30s who kept checking his phone. At 9:30, the bailiff called us in. Judge Harper's courtroom was smaller than I expected, with wooden benches, a jury box that would not be used since this was a bench trial, and the judge's elevated bench at the front. We took our seats at the respective tables. Judge Harper came in and we all stood. She sat down, arranged some papers, and looked out at us. "Good morning. We are here for the matter of Daniels versus Sunset Ridge Estates Homeowners Association. Counsel, are we ready to proceed?" "Yes, Your Honor," both Gerald and Susan said. "Very well." Mr. Patterson, this is your complaint, so you may make your opening statement. Gerald stood and approached the podium. He looked confident and calm. Your Honor, this case is about an abuse of power and a violation of trust. The defendant, through its president Patricia Morrison, engaged in a scheme to generate revenue by improperly towing homeowners' vehicles and collecting kickback payments from the towing company. My client, Ryan Daniels, was a victim of this scheme. He purchased a boat, parked it on his own property, and without any advance warning or due process, the HOA had it towed and forced him to pay over $500 to retrieve it. The evidence will show that this action violated Arizona law, violated the HOA's own procedures, and was motivated by profit rather than legitimate community concerns. We ask this court to order the HOA to reimburse Mr. Daniels for all his expenses, to pay his legal fees, and to cease these improper practices. He sat down. Susan Feldman stood for the HOA's opening. Your Honor, this case is about a homeowner who knowingly violated clearly written covenant restrictions and now wants to avoid responsibility. Mr. Daniels signed documents when he purchased his home that explicitly prohibited parking boats in visible areas. He chose to ignore those rules. The HOA has a duty to all residents to enforce community standards. The towing was proper, the fees were reasonable, and Mr. Daniels' claims of conspiracy and fraud are baseless attempts to distract from his own violation. We ask the court to dismiss his claims and award the HOA its attorney fees for having to defend against this frivolous lawsuit. The first witness was me. Gerald walked me through the whole story, buying the house, buying the boat, parking it in my driveway, waking up to find it gone. I explained how there had been no warning, no phone call, no letter before the towing notice. Susan Feldman cross-examined me aggressively. She tried to establish that I should have known about the rules, that I was trying to play dumb to avoid consequences. But I stayed calm and stuck to the facts. Yes, I signed the documents. No, I had not read every page in detail at the time, but I had now. Yes, the rule about boats existed. But no, the HOA did not follow proper procedure before towing. The next witness was the expert on HOA management, Dr. Richard Kowalski. He had a PhD in community planning and had managed HOAs for 30 years. He testified about industry standards, about the importance of advance notice and due process, and about how kickback arrangements with towing companies were unethical and potentially illegal. Susan tried to undermine him by suggesting he was just a hired gun saying whatever he was paid to say. But he remained professional and backed up every statement with references to HOA management guidelines and Arizona statutes. After lunch, it was the HOA's turn to present their case. Patricia Morrison took the stand. Susan walked her through the same basic story she had told in her deposition, but now in front of the judge. She described the covenant restrictions, the board's decision to enforce them more strictly, and her position that Mr. Daniels had been treated the same as any other violator. Then it was Gerald's turn to cross-examine. He started gently, confirming basic facts, then moved in for the harder questions. Miss Morrison, you testified that Mr. Daniels was treated the same as other violators, but you also testified in your deposition that you did not send him any advance notice. Is that still your testimony? The covenant itself is notice, Patricia said. That is a legal conclusion. My question is factual. Did you or anyone else from the HOA send Mr. Daniels a letter, email, or phone call specifically about his boat before having it towed? No. Have there been other cases where you did send advance notice? Patricia hesitated. Sometimes. Can you explain what determines whether someone gets advance notice or not? It depends on the severity of the violation. So parking a boat in a driveway is more severe than other violations. It is a significant visual impact. Gerald pulled out a document. Your Honor, I would like to enter Plaintiff's Exhibit 12, which is a collection of photographs from the neighborhood. He handed copies to the judge and to Susan, then put images up on a screen. The photographs showed various properties in Sunset Ridge Estates. Several had boats or RVs parked in driveways. The photos were dated, showing that these vehicles had been there at various times over the past year. Miss Morrison, can you explain why these homeowners were not towed? Patricia studied the photos. I do not recognize all of these properties. But you can see they are in your neighborhood, correct? Same style mailboxes, same street signs. They appear to be, yes. So the rule about boats and RVs is not being enforced uniformly. We enforce it when violations are brought to our attention. Who brought Mr. Daniels' boat to your attention? I noticed it myself while driving through the neighborhood. And you immediately called the towing company. After discussing it with the board, yes. There is no record of a board meeting discussing Mr. Daniels specifically. When did this discussion happen? It was an email discussion. Can you produce those emails? Patricia looked at Susan, who stood up. Your Honor, we did not believe those internal communications were relevant, so they were not included in our document production. Judge Harper looked annoyed. Miss Feldman, opposing counsel, asked for all communications related to the plaintiff. Internal board emails discussing the decision to tow his boat would certainly be relevant. Do these emails exist? I will have to check with my client, Susan said. You have until tomorrow morning to produce them, the judge said. Continue, Mr. Patterson. Gerald smiled slightly. Miss Morrison, let us talk about the financial arrangement with Desert Storage Solutions. You testified that the HOA receives 20% of all towing fees. How much money has the HOA received from this arrangement over the past 2 years? I do not have that figure memorized. According to the financial records you produced, it is $62,400. Does that sound correct, if that is what the records say? Where does that money go? Into the HOA's general operating account. And then how is it spent? On various community needs. Landscaping, maintenance, administrative costs. Including your expense reimbursements, my legitimate expenses, yes. Gerald pulled out another set of documents. Let us go through some of these expenses. March 15th of last year, you charged the HOA $2,800 for a trip to Honolulu. You said this was for an HOA conference. Can you produce any documentation from this conference? I have already explained that I may have materials somewhere. It has been 6 weeks since your deposition. Have you looked for them? I have been busy preparing for trial. Too busy to find documents proving you actually attended a conference you charged homeowners nearly $3,000 for. Miss Morrison, was there actually a conference or was this a personal vacation? There was a conference. What was it called? Patricia faltered. I do not remember the exact name. What hotel was it at? I do not remember. Can you name a single session you attended or speaker you heard? Patricia was silent, her face flushed red. Miss Morrison, I am going to ask you directly. Did you use HOA funds to pay for a personal vacation to Hawaii? No. Then produce the documentation proving otherwise by tomorrow morning. Susan stood up. Your Honor, counsel is badgering the witness. Your Honor, I am attempting to establish whether the witness committed fraud against her own homeowners. Gerald shot back. Judge Harper held up a hand. I will allow the questioning, but let us move on. Mr. Patterson, do you have other areas to cover? Just a few more, Your Honor. Gerald turned back to Patricia. Let us talk about the decision to tow Mr. Daniels' boat specifically. You said you noticed it while driving through the neighborhood? Yes. What day was that? I do not recall exactly. Was it the same day it was towed? I believe so. So you saw the boat, and within hours arranged to have it towed, without any attempt to contact Mr. Daniels first. It was a clear violation. Miss Morrison, is not it true that the real reason you had the boat towed so quickly was to generate revenue from the towing fees and your kickback arrangement? That is absolutely not true. Then why the rush? Why not send a letter, give him 2 weeks to move it, follow proper procedure? We do not have to give warnings for every violation. Actually, under Arizona law, you do. Your Honor, I have no further questions for this witness. Patricia stepped down, looking shaken. Susan called the representative from Desert Storage Solutions, whose name was Mike Henderson. He testified about the towing operation, confirmed that they had an agreement with the HOA, and tried to make it sound like a normal business relationship. Gerald's cross-examination was brief. Mr. Henderson, in your experience, is it common for HOAs to receive 20% of towing fees? Some have arrangements with towing companies, yes. But 20%, that is a fairly high percentage, is not it? It varies. In fact, most HOAs that contract with towing companies pay a flat fee for the service, rather than receiving a percentage, correct? I suppose that is also common, because receiving a percentage creates an incentive to tow more vehicles, correct? I can see how someone might view it that way. And if an HOA is making money from towing, they might be motivated to tow vehicles even when it is not strictly necessary, right? That would be up to the HOA's discretion. No further questions. The trial continued into the next day. Susan tried to present evidence that other homeowners supported the covenant restrictions, but Gerald got most of it excluded as irrelevant, since the issue was not whether the rules were valid, but whether they were properly enforced in this case. The emails between board members never materialized. Susan claimed Patricia could not find them, which Judge Harper clearly did not believe. The documentation from the Hawaii conference also never appeared. Closing arguments came on the afternoon of the second day. Susan argued that HOAs needed enforcement power, and that Mr. Daniels was trying to undermine that. Gerald argued that power without accountability was tyranny, and that Patricia Morrison had abused her position for personal gain. Judge Harper took everything under advisement and said she would issue a written ruling within 30 days. Those 30 days were agonizing. I tried to stay busy with work, with friends, with anything to keep my mind occupied. Gerald said the trial had gone well, but he cautioned me not to get my hopes up too high. Judges could be unpredictable. The ruling came on a Thursday morning in late March. Gerald called me at work and I stepped outside to take the call. We won, he said. We won everything. My knees almost gave out. What? Judge Harper issued her ruling this morning. She found that the HOA violated Arizona statutes by failing to provide advance notice. She found that the kickback arrangement with the towing company was improper and constituted a breach of fiduciary duty. She ordered the HOA to reimburse you for all towing and storage fees, to pay your attorney fees in full, and here is the big one. She found that the HOA acted with reckless disregard for your rights and awarded you punitive damages. How much? $50,000. I had to sit down on the curb. $50,000, plus your attorney fees, which are going to be around $12,000, plus the $525 you paid initially, plus the storage fees you have been paying for the boat, which you documented as about $1,000. So all in, the HOA owes you around $63,000. I could not speak. I just sat there holding the phone, listening to Gerald explain the details of the ruling. Judge Harper had eviscerated the HOA in her written opinion, saying that Patricia Morrison's conduct was a textbook example of abuse of power, and that the financial arrangement with the towing company raises serious questions about fraud and self-dealing. "There is more," Gerald said. The judge ordered the HOA to immediately cease its arrangement with Desert Storage Solutions and to refund fees to any other homeowners who were towed under the same arrangement. She also referred the matter to the Arizona Attorney General for criminal investigation. Is Patricia going to jail? That is up to the Attorney General, but she could face charges for embezzlement and fraud. At minimum, she is done as HOA president. The news spread through Sunset Ridge estates like wildfire. That evening, my phone rang constantly with neighbors calling to congratulate me or to ask questions about the ruling. Tom, the guy with the RV, said he was filing his own lawsuit the next morning. Jennifer, with the work van, said she was doing the same. Within a week, the HOA held an emergency meeting to remove Patricia Morrison from the board. I attended that meeting, sitting in the back of the community center with my arms crossed, watching as homeowner after homeowner stood up to express their outrage. Patricia tried to defend herself, tried to claim she had done everything for the good of the community, but nobody was buying it. The vote was unanimous. She was out. A new board was elected with a specific mandate to clean up the mess. One of their first actions was to revoke all the covenant restrictions on boats and RVs, deciding that homeowners should be able to use their own property as they saw fit within reason. They also hired a forensic accountant to go through all of Patricia's expense reports and determine exactly how much money she had taken. The Attorney General's investigation took several months. In August, Patricia Morrison was charged with 6 counts of fraudulent schemes and artifices, 3 counts of theft, and 2 counts of computer fraud. The case alleged that she had stolen over $70,000 from the HOA over a 3-year period through fake expense reports, and the kickback scheme. Her trial was scheduled for the following spring, but she ended up taking a plea deal in November. She pleaded guilty to 3 felony counts and was sentenced to 2 years in prison followed by 5 years of probation. She was also ordered to pay full restitution to the HOA and to all affected homeowners. As for me, I got my check from the HOA in early May. $63,125. I deposited it and paid off Gerald's legal fees immediately. The rest I put into savings, except for one splurge. I bought a brand new boat. The HOA's insurance company had to pay the judgment since it involved board actions, and Judge Harper's ruling had specified that, as part of the punitive damages, the HOA was responsible for replacing my boat with a comparable new model, since the whole situation had caused me to incur storage fees and lose use of the boat I had purchased. The insurance adjusters argued about it for a while, but eventually they cut me a check for $42,000, which was enough to buy a brand new 2026 Bayliner VR6. It was beautiful. White and blue like my old one, but newer, faster, with all the latest features. I had it delivered on a sunny Saturday morning in June and parked it right in my driveway, in the exact same spot where the old one had been. Several neighbors came over to admire it. Marcus drove up from Temp with a cooler of beer, and we christened the new boat by sitting in it in the driveway, drinking and laughing about how far things had come. "You know what the best part is," Marcus said. "What is that?" "That boat is worth more than the one they towed. You actually came out ahead." He was right. Between the new boat, the cash settlement, and having all my legal fees paid, I ended up about $40,000 better off than I had been before this whole thing started. It would have been nice to have that money without the stress and hassle of a lawsuit, but there was a certain satisfaction in knowing that Patricia Morrison's greed had ultimately backfired completely. The new HOA board turned out to be reasonable people. They focused on actual community improvements rather than nitpicking enforcement. They were transparent with finances, holding regular meetings where homeowners could review budgets and ask questions. The neighborhood felt different, more relaxed, less like living under constant surveillance. I kept the boat in my driveway all summer, took it out to Lake Pleasant almost every weekend. Sometimes I would come home and see other neighbors' boats and RVs parked in their driveways too, and it felt like a small victory for common sense. In September, I got a letter from the Attorney General's office. It thanked me for my cooperation in the investigation and informed me that my actions had led to systemic reforms in how HOAs were monitored in Arizona. The state legislature had passed a new law requiring HOAs to register with the state, to maintain transparent financial records, and to follow strict due process procedures before taking enforcement actions. Violations could result in fines and personal liability for board members. The law was being called the Homeowner Protection Act, though some people jokingly referred to it as the Patricia Morrison Prevention Act. I never saw Patricia again after her sentencing. I heard through the neighborhood grapevine that she moved out of state after getting out of prison, probably to escape the stigma. Her house sold quickly to a young family who seemed nice enough. As for me, I learned some valuable lessons from the whole experience. I learned to read contracts more carefully before signing them. I learned that standing up for your rights can be expensive and stressful, but sometimes necessary. I learned that corruption can exist even in seemingly mundane places like homeowner associations. And I learned that the legal system, for all its flaws and delays, can actually work when you have the facts on your side and the determination to see things through. But mostly, I learned that you should never mess with a man's boat. On a warm October evening, I was sitting on my back patio, grilling dinner and enjoying the sunset. My phone rang. It was Gerald Patterson. "Ryan, how are you doing?" "Good, Gerald. What is up?" "I just wanted to let you know that the last of the restitution payments from Patricia Morrison came through. Every homeowner who was affected by the towing scheme has been fully reimbursed. It is finally all wrapped up. That is great news. It really is. You know, in 25 years of practicing law, this case is going to be one I remember. You did a good thing here, Ryan. A lot of people benefited from your willingness to fight." "I just wanted my boat back," Gerald laughed. "Well, you got that and then some. Take care of yourself." After we hung up, I stood at the edge of my patio, looking out at the neighborhood. The sun was setting behind the mountains, painting the sky in shades of orange and pink. My boat sat in the driveway, gleaming in the evening light. Inside the house, the air conditioning hummed quietly. Everything was peaceful. It had been a long road from that Tuesday morning when I woke up to find my boat missing. Months of stress, legal battles, depositions, and court appearances. But standing there in that moment, it all felt worth it. Not just because I won, or because I got a new boat, but because I had stood up for something that mattered. I had refused to be bullied, refused to accept that might makes right. The next morning, Sunday, I hitched up the boat and drove out to Lake Pleasant. The drive took about 40 minutes, winding through desert landscape dotted with saguaro cacti. The lake was busy with other boaters, families enjoying the last warm weekends before winter. I launched the boat and spent the day on the water, just cruising around, feeling the wind and spray. No destination in mind, no agenda, just freedom. As the afternoon wore on, I found a quiet cove and dropped anchor. The water was calm, reflecting the blue sky. I sat in the captain's chair, feet up, cold drink in hand, and thought about everything that had happened. Patricia Morrison had thought she could push me around, take my property, and profit from it. She had thought wrong. The legal system had held her accountable. Justice had been served, both civil and criminal, but beyond my individual case, things had actually changed. The new state law meant other homeowners would have better protections. Other HOAs would think twice before engaging in similar schemes. It was a small victory in the grand scheme of things, but meaningful nonetheless. I stayed out on the lake until sunset, watching the colors change across the water. Other boats headed back to shore, leaving trails of wake that eventually smoothed out to glass. The desert hills turned purple in the fading light. When I finally loaded the boat back on the trailer and headed home, I felt a sense of contentment that had been missing for a long time. The fight was over. I had won. Life could go back to normal, but a better normal than before. Back in Sunset Ridge Estates, I pulled into my driveway just as the streetlights were coming on. A couple walking their dog waved to me. I waved back. The neighborhood felt like home again, not like enemy territory. I parked the boat in its usual spot, right where everyone could see it from the street, where it belonged, where it would stay. Inside, I made a late dinner and settled on the couch to watch a game. My phone buzzed with a text from Marcus. "How was the lake?" "Perfect," I texted back, and it was. Everything was. The legal battle was over. Patricia Morrison was facing the consequences of her actions. The HOA was under new management, and I had a brand new boat that was better than the one I started with. Sometimes life works out in unexpected ways. I thought about all the homeowners who had called me after the verdict, thanking me for fighting, telling me their own stories of HOA overreach. Some of them had filed their own lawsuits and won settlements. Others had joined together to reform their own boards. The ripple effects of one person standing up were wider than I had imagined. That night, I slept better than I had in months. No anxiety about legal deadlines, no anger about injustice, no worry about money. Just peaceful, deep sleep. In the weeks that followed, I settled into a comfortable routine. Work during the week, boat trips on weekends, occasional dinners with neighbors who had become friends through the whole ordeal. The community felt stronger somehow, brought together by the shared experience of holding leadership accountable. The new HOA board even asked me if I wanted to run for a position. I politely declined. I had done my part by fighting the corruption. Now I wanted to just be a regular homeowner, living my life without drama. Winter came to Arizona, which mostly meant slightly cooler temperatures and occasional rain. The boat sat in my driveway through it all, a visible reminder of the battle that had been fought and won. Sometimes I would catch people slowing down as they drove past, pointing it out, probably telling the story to whoever was in the car with them. Let them look. Let them remember what happens when HOAs abuse their power. Let them remember that homeowners have rights that cannot be trampled. Spring arrived with desert wildflowers blooming across the hills. I started planning longer trips on the boat, maybe down to Lake Havasu or even out to California. The world felt open in a way it had not before. One Saturday morning in April, almost exactly a year after Judge Harper had issued her ruling, I was washing the boat in my driveway when a car pulled up. A man about my age got out, looking nervous. "Are you Ryan Daniels?" he asked. "I am. My name is David. I live over in Mountain View Estates, a few miles from here. I am having a problem with my HOA, and I heard about what happened with yours. I was wondering if I could ask you some questions." I turned off the hose and invited him to sit on the tailgate of my truck. He told me his story. The HOA was trying to fine him for having too many plants in his front yard, claiming it violated landscaping guidelines. They were threatening daily fines of $100 if he did not remove them. "Have they given you any written notice?" I asked. "Just a letter saying I am in violation." "Did they give you a chance to contest it before issuing fines?" "No." I grabbed my phone and pulled up Gerald Patterson's contact information. "Call this lawyer. Tell him I sent you. He specializes in HOA disputes and he is very good." David took the number, looking grateful. "Thank you. I just did not know where to start." "Start by documenting everything. Take photos, save all correspondence, keep detailed records, and do not let them bully you into just paying up. If they are violating procedure, fight it." We talked for another 20 minutes. I shared what I had learned, what to expect from the legal process, how to stay strong when it felt overwhelming. By the time David left, he seemed more confident, more ready to stand up for himself. After he drove away, I went back to washing the boat, but I felt good. The fight I had fought was helping others. The system was working the way it was supposed to. That evening, sitting on my patio with a cold beer, watching the sun set over the neighborhood, I realized something. The boat was never really the point. Sure, it was what started everything, and I was glad to have a new one. But the real victory was bigger than that. The real victory was proving that regular people can stand up to power and win. That corruption gets exposed when someone shines a light on it. That doing the right thing, even when it is hard and expensive and stressful, matters. My phone rang. It was my mom calling from Ohio, where I grew up. "Hi, honey, how are you?" "I am good, Mom. Really good. I saw on Facebook that you were out on the lake today. The boat looks beautiful." "It is. You and Dad should come visit and I will take you out. We would love that. We are so proud of you, for everything you did." "Thanks, Mom." After we hung up, I sat there thinking about family, about the values I had been raised with. My parents had always taught me to stand up for what is right, to not let anyone push you around, but also to be fair and honest in your dealings with others. Those values had guided me through the whole situation with the HOA. The stars were coming out now, bright in the clear desert sky. I could hear distant sounds of the neighborhood, someone playing music, kids laughing, dogs barking. Normal, peaceful sounds of community life. This was what it was supposed to be. Not a battlefield where homeowners and HOA boards fought each other, but a place where people lived together, respected each other's rights, and worked together when problems arose. The new HOA board seemed to understand that. Their approach was collaborative rather than combative. They asked for input before making decisions. They were transparent about finances. They treated homeowners like partners rather than subjects. It made all the difference. As I finally headed inside for the night, I took one last look at the boat in my driveway. Tomorrow I would take it out again, maybe try that new fishing spot Marcus had told me about. But tonight, I would just appreciate how far things had come. From having my boat towed and being threatened with fines, to winning a landmark court case, to having a brand new boat and being part of positive change in HOA laws across Arizona. It was quite a journey, and it all started because I refused to accept injustice. Because I was willing to fight for what was right. Because I believed that one person standing up could make a difference. I was right to believe that. The story could have ended differently. I could have paid the fees and moved the boat and never made waves. Patricia Morrison would have continued her schemes. Other homeowners would have continued to be victimized, and nothing would have changed. But I fought. And because I fought, things got better. Not just for me, but for countless other homeowners across the state. That is what made it all worthwhile. That is what I would remember years from now when the details of depositions and court hearings had faded. I would remember that I stood up, fought back, and won. As I locked up the house and headed to bed, I felt genuinely happy. Not just satisfied with the outcome, but happy with who I was and the choices I had made. In a world that often feels overwhelming and unfair, I had found a corner of it that I could actually influence for the better. My boat sat in the driveway under the stars, and tomorrow it would be there too, right where it belonged. Right where no HOA president would ever touch it again without facing serious consequences. Justice had been served. Accountability had been enforced. And one man's boat had become a symbol of why we all need to stand up when institutions abuse their power. It was a good feeling. The best feeling. And as I drifted off to sleep that night, I smiled thinking about all the weekends ahead on the water, all the adventures yet to come, all the freedom that I had fought for and won. The boat was just a boat. But it represented something much bigger. The right to live your life on your own property without arbitrary interference. The right to due process and fair treatment. The right to hold leaders accountable when they abuse their positions. Those rights are worth fighting for. I had proven that. And I would never forget the lesson.